Disclaimer. Judge Ron Rangel is providing this podcast and website for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I'm your host. Today in the studio, we have Lauren Scott. Now, Lauren grew up in Louisiana, joining the Air Force after high school, and was an enlisted medic with the Air Force Reserves from 1995 to 2003. She subsequently moved to Texas in 1999. She decided to go to law school when her son was 3 years old and earned her bachelor's degree from St. Edward's University in Austin. And after that, she moved to San Antonio to go to law school at St. Mary's. Originally, she wanted to be a defense attorney and specialize in representing juvenile offenders, but she started working at the DA's office as an intern in 2006, and she never left. Now, she spent the majority of her time in the DA's office in the appellate section, but moved to a trial position in the Family Violence Division in 2019, and now I have the privilege of having her in the 379th. Welcome, Lauren.
Thank you, Judge. It's a privilege to be here.
I appreciate you coming in. I've been trying to get you for a while.
I mean, I don't know. I guess I've been busy, Judge, right?
I've been trying a lot of cases.
We've been working really hard this year, really hard.
Agreed. And I think that's kind of across the board, sort of post-COVID, trying to catch up with all the trials that are backed up. Your cases in the family violence section are harder to negotiate and harder to plead. Would you agree with that?
I do agree with that. Yes. They bring their own challenges that cases where the perpetrator and the victim are not known to each other do not have. Yeah.
All right. So tell us specifically what you do at the district attorney's office.
So in my division, we focus on crimes that occur between family members. And so under the family code, there is a specific definition of what constitutes a family member. Could also be a dating relationship or members of the same household. So we do those cases. I also do cases of crimes against children. So that could be an injury to a child, could be sexual assault of a child, decency with a child, those types of offenses. It could even be murder cases where, unfortunately, a child is the one who died. Those are what we focus on, crimes against children and crimes between family members that are at a felony level.
So the family violence relationship could be hard to define, right? Because you mentioned things like a dating relationship. What would constitute a dating relationship?
I think, Judge, I've started to use a term called intimate partner violence. I think getting away from an older term of family violence, I think intimate partner violence can kind of encompass more relationships. Mm-hmm. So it could be people who live together. Mm-hmm. It could be people who are dating and are intimate. It's more than just your one night stand, your mere acquaintance. It's going to be a relationship where there is sort of repeated meetings, right?
What about good friends that go out to dinner often?
That would not constitute a sort of intimate partner violence sort of situation.
So the intimate partner violence situation would involve a relationship, meaning some romantic involvement.
Right. We would look at the nature of the relationship, the frequency of how often the couple comes together. It's not defined by gender, but just by the nature of the relationship and the frequency of what the parties have decided that their relationship means to each of them.
So you're a prosecutor in the DA's office. And so prosecutors have to approach cases in a different way than a defense attorney does.
Yes. Prosecutors, under the professional rules of responsibility in Texas and under the Code of Criminal Procedure, have a different and specific responsibility that is not put upon any other lawyer in the state of Texas.
So a prosecutor's duty then is not to seek convictions. I think a lot of people have that idea.
I agree.
What specifically is a prosecutor supposed to do in the state of Texas?
A prosecutor is tasked to always seek justice, not convictions, but to seek justice.
All right, so how is that different than from a defense attorney's viewpoint?
Defense attorney has a client. And so they are, under the law, they have to advocate for their client. They have to advocate for the interest of their client. They have to do everything that they can under the law, under the rules of evidence, under the constitutional protections to zealously advocate for their client's interest. Where what prosecutors have to do is seek justice. We have an obligation to even defendants, right? So even though they're not our client, we have an obligation to make sure they have all of the evidence that we have, an obligation that the procedural safeguards that the Constitution puts upon us are being met, and the defendant is afforded those rights. We also have an obligation to the defendant, and sometimes even a bigger obligation to the defendant than maybe even defense attorneys might see, right? Because we're having to look out for the rights of the citizens that are accused, even though we are at the same time maybe trying to seek a prison sentence for that person.
All right. So if an individual then is a victim of crime, who would represent that particular person? Let's say that there's a family violence assault. Who would represent the individual that has been assaulted?
So there's no one that represents their interest in that attorney-client sort of relationship. We, as prosecutors, obviously use complainants as our witnesses. They are a part of our evidence. They are a part of our case, but we are not their attorney. There is not an attorney-client relationship that is afforded to the complainants in criminal cases in Texas.
So as a result of that, if you have a situation where, let's say, a defense attorney is representing a client, a defendant, then there is a known attorney-client relationship between those two. But if a complainant is giving you information, do you have that same type of relationship with that complainant?
No, we do not. So an attorney is tasked with confidentiality of things that their client tells them. We actually have the opposite. So when a complainant or a witness gives us information regarding the case, we have an obligation to make that available to the defense. And under the code, we are required to turn over that information. We cannot keep anything confidential that a witness or a complainant might tell us.
So there are confidential bits of information that you obtain in dealing with complainants. Is that right?
Sure. Like we can keep private information, phone numbers, social security numbers, addresses, that sort of information we are allowed to keep private. But as far as the substance of what testimony might be, what a person witnessed, what they know about the defendant, that sort of substantive information we have to turn over.
And that really changed subsequent to the Michael Morton Act. Is that right?
Correct.
If we just want to explain to those that are listening in, what specifically is the Michael Morton Act and how did that change what prosecutors do?
So before the Michael Morton Act, the state did not have an obligation to turn over the evidence or what we call the discovery in the state's file unless and until the defense requested and showed good cause for that information. I will say in Bexar County, Texas, even before the Michael Morton Act, we had a general open file policy where the defense attorneys could come in, look at our file, look at the police report, look at our evidence.
They could take notes.
But
they wouldn't make copies of documents.
Correct. But after the Michael Morton Act, the legislatures have put an obligation upon prosecutors where they must turn over all relevant material evidence that is in the possession of the state and allow the defense attorneys to have access to those copies. So for example, we have a lot of digital evidence now in the forms of body-worn cameras and 911 calls, witness statements are recorded. We have to actually provide that information where the defense can have access to it and have copies to it. There's only one small exception to that rule when we have a child who has been forensically interviewed, a victim of potential sexual assault. We do not have to turn over copies of that, but we do have to allow the defense attorneys to have reasonable access to that material where they can view it and take notes and have access to it.
And just so people know, how did the Michael Morton Act come about? Who was Michael Morton? What was the circumstance behind what happened to him?
Well, Michael Morton was a man who was accused in Williamson County and convicted of murdering his wife. There was information that the state had, the prosecutor at the time had, that they did not turn over to the defense. Even though they were actually ordered to turn over some of the information by the judge, they failed to turn over a statement that a child witness said and some other evidence that there may have been another person that would have been the suspect, that could have been the person that actually did the murder, and they withheld that information from the defense. So that's sort of the beginning of why that kind of was created, is that we don't want to get convictions based on withheld evidence or edited evidence. We want to get convictions knowing that the defense and the accused have all of the evidence that the state also has.
And as a result of that case, Michael Morton was sentenced to life in prison, and he did about 25 years.
Correct.
And so that then makes it incumbent upon prosecutors to make sure that they share all the information, not just information that could be considered exculpatory.
Yes.
Right? Because in the older days, prosecutors would say, I had that evidence. I didn't turn it over because I didn't think it would be a benefit to the defense. Pre-Michael Morton, which was about 8 years ago, maybe. Is that a good?
2013, I think, is whenever it went into effect.
Almost a decade. Well, actually a decade now, right? So as a result of that now, there's a lot more work that prosecutors have to do, right? Because you have to review everything. Yep. Right. And there's no longer that concept of what is a prosecutor's opinion as to what it is that is exculpatory or something that could be a benefit to the defense. So what happens then when you have a complainant? Let's say that there's a victim in a family violence assault. We'll just keep it simple. And they're telling you, I want this person to get the maximum term in prison. How does that affect what you do?
I take it into consideration. I always listen to all of my complainants with an open mind. But at the end of the day, I have to evaluate the strengths and weaknesses of my evidence, what I think I can and can't prove beyond a reasonable doubt to a jury. And then also I have to look at just what the members of the community, right, the people of Bexar County who the office represents, what they're kind of telling us with their verdicts. We kind of look to what is the community telling us when they're coming down with their punishments, or they're guilties or not guilties, or when we talk to jurors after the fact. It's the desire of the complainant can be something that I take into consideration, but I can't let it determine what my offer might be or what the ultimate resolution might be. At the end of the day, it has to be the evidence that kind of drives it. And then also you take into consideration the defendant's criminal history, whether they have a prior conviction for a felony, whether they've got prior family violence convictions, or do they have no criminal history? Are they young? Are they old? What is their background? Do they have mental health issues? There's a whole slew of things that kind of go into, I think, prosecutors' consideration on what might be a fair and just resolution.
So something like that is based on the characteristics of the defendant, things like prior criminal history, social history, family history, all those other things. But lately in the media, we've seen a lot of attacks on things like plea bargains. And so one of the things that I've always argued is that there are other factors that go into consideration as it relates to plea bargains, like the strength of the case. Let's say you're interviewing a complainant or a witness, and their testimony doesn't quite come out the same way as it reads in a police report. How often do situations like that happen?
Very often. I think it's just the nature of the human memory, human sort of ability to relay. Trauma can kind of play a part in it too, and it can affect memory. Time can affect memory. So there are times whenever a complainant statement might be even slightly inconsistent from what they might have told to the police at the initial investigation.
You and I have had communications regarding crime victims' rights, specifically the fact that constitutional rights have been in existence since we created the Constitution. But crime victims' rights are really a fairly recent phenomena. Is that right?
Yeah, it is. It's something that kind of we come up against. Sometimes complainants don't understand that we're not their lawyer. We don't represent them. And they often, understandably so, feel like all of the rights are afforded to the accused and victims don't have any rights. And so I think what the legislature tried to do is in the 80s, they wanted to kind of give some rights to the victims. And so they enumerated a series of rights afforded to victims, both in the Texas Constitution and in the Code of Criminal Procedure. But that wasn't until the 1980s that even was codified.
What kind of rights did they look at?
The main ones that the legislature were focusing on are a right for a victim to be treated with respect and fairness. And I think you, Judge, definitely have this philosophy that that's how we treat everybody. And I mean, that can look like, I listen, right? We listen to our complainants, we listen to our victims, even if we can't give them exactly what we want, try to make them understand our perspective and where the prosecutors are coming from, what our jobs are about. And I hope that that's a part of treating them with respect and fairness, giving them information about the process and the procedure. And then the other big part that the legislature wanted was to make sure that the victims were safe from their perpetrators. And there's abilities, tools, I guess, that the prosecutor can have and the judges have too, in order to make sure that victims of crime feel safe from their perpetrators.
There's a couple of things that I think of when you talk about those two particular rights of victims, according to the statutes and the Constitution. First, you're talking about the right to be treated with respect and fairness. How common is it for you to come across a complainant or a victim who is going through basically the worst or one of the worst experiences of their lives, and they feel like there's nobody there to help support them, and they want something out of the justice system that maybe is not possible? To me, that would be a fairly common experience for a prosecutor.
Yeah, it does. It's a tough place to be because as a human, I have the desire to want to fix the problems that this person has, the harm and the trauma that they've endured.
Right.
But I can't fix it. I can't change it. I often think of prosecutors as like, we're after the fact, we are about, okay, this really bad thing happened. Now, what is the appropriate consequence for this really bad thing that happened? Nothing that we do, even if we put a person in prison for a lot of years, is going to take away the fact that they lost a child or a mother or a brother. That's still going to exist. And that's a hard thing to have to look at somebody who has been through so much and knowing that we can't fix anything. We can just try not to do more harm.
Well, I've seen victim impact statements where victims say, I lost like $3,500 that I had to pay as a result of this crime, economic damages, but also should get reimbursed for pain and suffering. Right? That's probably a common. How do you deal with that situation?
Just as respectfully and professionally as I can, explain that that's not allowed under the law, that there could potentially be civil remedies, but they would have to get an attorney to represent those interests, a hired attorney to represent those interests. But under the law, we are allowed to seek monetary damages and or restitution with regard to medical bills that from any injuries that may have occurred as a result of the assault. We can also seek things like lost wages if the person spent time in the hospital or had to miss work as a result of the assault or the injuries. Those are the sorts of things that we can ask the court for, and the court can order if it's warranted.
Like purely economic damages.
Correct.
So then you talk about the right to be reasonably protected from harm from the perpetrator. I'm sure you get a lot of situations, and I've seen them in court with your cases where complainants come in and say, I wasn't really being completely honest when the police came out and I made this police report. So how do you handle those kind of situations?
That unfortunately is too common in intimate partner or family violence relationships, more specifically in either husband-wife relationships and or boyfriend and girlfriend relationship, especially when there's children involved in the relationships. It's very common where I will have a complainant come and say, I want to drop the charges. They often sign things called affidavits of non-prosecutions. Those are fairly common, where they're telling the state, the prosecutor, hey, I'm not going to hold you liable if you decide to dismiss the case. I would like for the case to dismiss. They sometimes can go so far as just to tell me they're not going to cooperate and or say that they completely lied to the police and they made it all up, even though I might have pictures of pretty severe injuries and or even other independent witnesses that corroborate that assault did occur. My personal perspective is to look at the strength of the case without the complainant's involvement. If I can prove the case beyond a reasonable doubt without the complainant's involvement, because I've got other witnesses and or other pieces of evidence, maybe I try to do that and pursue the case. But then there's sometimes where I can't.
It's not a certainty that it would have a negative impact on prosecuting that case, but it is a factor.
Correct.
And there's a lot of little factors that you have to consider when you're trying to figure out how will this case play out in front of a jury.
Right, exactly.
As it relates to victims' rights, how far should you go, or how far do you think you need to go? And when somebody comes to you and says, my spouse or this perpetrator, somebody that I financially rely on, right? That, I need this person to work. I need him out of prison. I need him in my life. How far do you think you need to go? It's a difficult proposition. And I tried a lot of family violence cases as a prosecutor back when I was a prosecutor. So I understand how tough it is when somebody comes in and tries to weaken your case from that perspective. How do you handle that type of thing? Is there some sort of counseling that you can refer these folks to, or what is it specifically that you can do to try to help them?
We do have victim advocates in our office, and they are the person that is tasked to provide whatever services we can. So our office specifically doesn't have any counseling service or intimate partner violence or victim services. But what we do have is a list of resources where we can try to encourage people to reach out to. We also have the Family Justice Center that our office is a part of. That's kind of across the street. And that's a more full service. They have counseling there, group counseling, individual counseling. And so we can try to guide people in those directions. But at the end of the day, we can't force them to do any of that. And then I have to look at each case individually and decide, is this person really at risk of future harm? Do I think that this person is someone that potentially could be harmed again? And then I look to see if I have any tools within the law to maybe a no contact order, protective order, or maybe I try to prosecute the case even without the complainant's assistance.
I've read some statistics that indicate that the more a victim or a complainant is involved in the prosecution of the case, the stronger that case would be when you take it in front of a jury. Have you had that experience?
I think it depends on the case. Judge, we've actually tried a couple of cases in your court where we didn't have the complainant for one reason or the other, and we were successful in those cases. And then we've had cases where the other way, where we've had the complainants and they testify, and then we do fine there too. But then we've had cases where we've had the complainant testify and the jury didn't like the complainant. So I think it kind of depends on the case. What other evidence you have, and it's always great for the state to have corroborating evidence and not have to solely rely on the testimony of one person.
If somebody, and I know based on the kind of work that you do, you deal with child cases where children are victims in aggravated sexual assaults. There are times when the media has picked up on cases where somebody got deferred adjudication on that. And we've had that conversation where the media would report it in a way that says, this person got deferred adjudication, therefore there is no criminal record, or there's no record indicating that they had this type of probation. Also, what are some of the factors that you look at when you're having to deal with those kind of cases?
Well, and specifically if it's a child victim, then there's the serious consideration of whether I want to re-traumatize a child by putting them on the stand.
That's something to consider.
It's a really big one. We have a child, a minor, who's already been through something that I don't think most of us can even comprehend or understand. And then to ask them to get on the stand, which you and I have seen is hard for adults, even police officers, people that do this as a profession have a hard time testifying sometime. And then to ask a child to get up on the stand in front of a bunch of strangers, face their perpetrator, and to talk about in detail some of the worst things that have happened to them. Always mindful of that when I take it into consideration. And sometimes children come to us and they're dealing with a lot. They're dealing with their own mental health struggles. And we have to make sure that we're not doing more harm to that child. So I'll often look to the parents or the guardians to kind of guide me that way to see, hey, this is just not something that we want to put the kid on the stand. Is there some way that we can resolve the case without putting the child on the stand to testify? And sometimes that means, as prosecutors, we agree to a deferred adjudication community supervision. What we like about it is that the child doesn't have to testify. What we don't like about it is it means that the person still is amongst community supervision. But we've got tools for that too. They still are required under the law to be a registered sex offender. They are in the most intensive unit with Bexar County adult probation. They have such conditions as they have to take a polygraph and admit what they did. They have to avoid certain internet sites. They can't live with children. They're monitored very closely. So it's definitely a balancing act. That's not easy. It's not black and white at all. It's very complex.
In those types of cases, that deferred adjudication will always be on the record because it is a sex case.
Correct. It's not something they can get expunged. And they will always have the sex offender registration requirement to also.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
All right, Lauren, we have a question. Do prosecutors have their own detective like they do on the crime shows?
No, we don't. Now, what we do have is we have internal investigators, but the prosecutor's office isn't tasked necessarily with going out and collecting evidence. We can do that on occasion, but generally we rely on the detectives, whether it's our Bexar County Sheriff's Office detectives or San Antonio Police Department detectives, to collect and deliver the evidence to us. Our internal investigators are there to do things like background checks on witnesses, right? To make sure that we have witnesses and know their full background check on the defendants. Do they have any criminal history outside of Texas, outside of Bexar County? They're also tasked with subpoenaing our witness. When it comes time for trial, if I'm trying to locate a person and I need to hunt them down and get them into court, they often will help us with that. But generally, we want our cases to come to us as fully investigated as they potentially can be.
So you don't actually go out to scenes like they do in the movies or on TV.
I am not one of those prosecutors that goes to the scene. I know some prosecutors do, but I'm not one of those. My job doesn't require that. Yeah.
I did it a couple of times when I was a prosecutor, but it was more for the bigger cases. Maybe
Sure.
there was a really heinous murder and I wanted to get a feel for what was going on. But there was nothing substantively that I collected. It was more of a sense of what it is that the scene looked like. That way, when I took it before a jury, I could sort of play it in my head a little differently. But you do work hand in hand with detectives and policing agencies to collect that evidence.
Right.
Well, that makes sense. Thank you for asking that question. That's a really good one. Please submit your questions at beyondthegavelpodcast.com and we'll continue to answer them on the air.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back. I'm here talking to Lauren Scott. All right, so a recent phenomena is something called victim impact statements, and they could use in different ways, right? You want to sort of tell us what that means?
Sure. So under the Code of Criminal Procedure, victims have a right. It's not a requirement, but they have the right, if they choose to exercise it, to do something that's called a victim impact statement. And I want to step back a little bit just because I want to make it clear. So victim is specifically defined by the code. The Code of Criminal Procedure defines a victim as someone who has suffered sexual assault, kidnapping, aggravated robbery, trafficking, injury to a child, elderly, or disabled person. It also means any person who has suffered personal injury or death as the result of the criminal conduct of another. And I point out that definition because what I found interesting when I first started doing this job is, what do you notice kind of lacking from that? Like property crimes, people who maybe their vehicles were burgled or had a car stolen or had property stolen from them. Technically, under the Code of Criminal Procedure, they are not defined as a victim when we're talking about all of the rights that we're talking about now. It seems like the legislature is focused on children, elderly, disabled, and then people who have actually been personally injured. Or if they've been killed, then it's their family, their next of kin, who are considered the victims. So with that in mind, when we have a victim of a crime as defined by the code that I just read out, then they have the right, if they choose to exercise it, to do something that's called the victim impact statement. And so essentially what that is whatever they want to tell us, whatever they want to tell the criminal justice system, how the crime affected them, could be physically, mentally, financially, whatever that looks like for them. And then we're required under the code, the prosecutors and the judges, probation and parole, all of those entities within the criminal justice system are required to take that into consideration when we're doing our final dispositions, and probation and parole are deciding maybe what conditions the person must be under. We look at that victim impact statement when we make those considerations.
What about those victim impact statements that come after a sentencing?
Yeah, so they're entitled to do that. And what that is after Your Honor has sentenced a person, whether it's probation or prison or even deferred adjudication, then they have the right to stand up in court, face their perpetrator, and essentially give whatever's on their heart. That's kind of what I tell them. It's like, hey, whatever's on your heart, whatever you want to say, there's nothing really wrong or right. I just ask them, don't use curse words and don't make threats. It's still a courtroom, but whatever might help them sort of close this chapter of this process, that's their time and their place to do it.
It's an opportunity for them to express whatever it is that's been heavy on their minds, whatever it is that they need to get out, to tell either the court or the defendant or society in general, right?
Right, exactly. I mean, I think we've heard it all, Judge. I mean, you've heard it from, I hate you forever, I'm never going to forgive you, to I've forgiven you, and I'm moving on, and I'm stronger and better now, so it kind of runs the whole gamut of emotions, those victim impact statements.
I think those have been kind of effective at helping victims of crime feel like maybe they had a voice.
I agree.
Yeah. And so what's the difference between a victim impact statement before the sentencing versus after the sentencing?
It can contain the same basic information, but the victim impact statement before, there's just a requirement for the prosecutors, the judge, probation, and parole to take that into consideration when they're making their final decisions of the disposition of the case, where the oral one in court really is just for the victim, right? Just for their moment of whatever they need to say if they choose that is something they need to do as a part of their healing process.
And because of that, then it's not something that's recorded on the record.
Right.
So there's no transcription of what it is that they said. The defendant doesn't really have a right to respond to them or communicate with them. They basically just have to stand there and listen to whatever it is that that victim says.
Correct.
That seems to be a good thing.
Yeah. They're not cross-examined by the defense attorney. Nobody's challenging them. It's just a moment to speak from their heart.
And when you consider the fact that there's nobody that actually represents victims, it really is their opportunity to feel like they're a part of the system.
Yeah, that they have a voice in the process too, and we're listening.
I've read some statistics that say that by and large, 70+% of victims of crime that have experienced the courtroom process walk away satisfied. Is that something that you've experienced?
I think so. It's easy to focus on the negatives, and it seems like the media likes to focus on the negatives. But when you look at most of my cases, I will say probably most people I deal with were, maybe if they're not happy, it's something they can live with, right? It's the end of something bad that happened to them, but they're okay with how it ended, and they have the ability to move on. I think that would be the majority of folks that I deal with.
I think most people would be happy to hear that.
Yeah. We never hear the good stories, Judge, right?
No, that's not how it works. And we never remember the good stories quite as easily.
That's true. It's true. But I mean, we have a lot of families. I have one story where, it was a hard case and we actually got a not guilty from the jury, and I felt horrible for this family, felt like maybe I failed them. It was just really, really hard on me. And I kind of held that for a while. Well, just so happened a few years go by and the brother-in-law of the victim just happened to reach out to my trial partner just randomly and sent him a text and said, hey, we know we didn't get the outcome that y'all wanted, but we want to thank you guys for trying that case because you really brought closure for our family. Just going through the process helped our family come together. It helped us heal. And they thanked us for doing that job, even though we didn't get a guilty. They felt like it was healing for their family to just have that process and to go through it. So,
and being in the position that you're in, what did that do for you?
It made me feel better. It made me feel like, that sometimes as long as we are doing like the Constitution says we're supposed to do and treat them with fairness and treat them with respect, that even though they've been through trauma and they've had loss, this doesn't necessarily have to be a horrible process for them, that they can actually, even moving through the criminal justice system, find some closure and find some healing, even if they've lost a family member. One
of the conversations I've had with a lot of lawyers is winning and losing in the courtroom does not mean guilty or not guilty, right? There's so much gray involved. Sometimes the parties just need to be heard.
Yeah.
And that's a big part of that process.
Yeah.
Right, just giving folks an opportunity to have their case brought before a fact finder and let them make the determination.
Right.
And then once that happens, then let the chips fall as they may. So you used to work in the appellate section at the DA's office.
I did.
And that's a very different type of work than somebody who's a trial lawyer.
Correct.
What was that transition like for you?
It was tough. So appellate is post-conviction and it is all reading and writing. So everything's already been said and stated and admitted.
You don't have live witnesses.
No live witnesses.
You don't have court reporters.
No court reporters. Basically, I just looked at a computer screen all day, read records, read case law, and then wrote my arguments down. I had time to contemplate and ponder and edit.
Make sure they sound just right.
Exactly. So it really is just about making the arguments, affirming that the trial court made the right decisions is at the end of the day what we're doing. And so, but now on this side, it's a lot more on the fly. I have to think on my feet a lot more. Definitely the interactions with the complainants and the witnesses on a daily basis is a huge difference. Meeting the kids, in person, it was a tough transition. So I don't know that anything from law school can really prepare you on how to be a sex crimes/family violence prosecutor.
And you never know what to expect in court.
Never know what to expect.
Right. There are times when I remember interviewing people and then you put them on the stand and they'll give you a totally different response in front of 12 jurors.
Yep. I've had that thought of, why am I hearing this for the first time today?
But that's something that you have to consider when you evaluate the strength of a case.
Correct.
Now, prosecutors have a lot of powers in Texas. Some have argued that the prosecutor is really the most powerful person in the courtroom because you think of things like discretion, which begins at the time of filing. You want to talk a little bit about what that discretion looks like as a prosecutor here in Bexar County?
So the discretion of the prosecutor is about looking at the evidence, looking at the case file that has been given to us by law enforcement, and deciding what are the appropriate charges. So we've got the code, the penal code. So we open up the penal code and say, hey, how does the evidence might fit the laws that we have? And that's where our big discretion is what sort of cases we even present to the grand jury, how we present them to the grand jury, and what charges we ultimately decide to indict on.
And so if a Texas prosecutor says, I don't think there's enough evidence, or this may not fit into some statute where we can charge somebody with a crime, so we're going to have to dismiss this case. What recourse then would a complainant or victim have as it relates to that charge?
So the code says that a complainant doesn't have any recourse with regard to the disposition of a criminal case. They're not a party to the criminal case, and they cannot contest the disposition of it. It's between the prosecutor and the judge and the defense attorneys about the resolution. We have a duty to inform the complainants, right? They have a right if they request to have information. So we often will call them and tell them, hey, this is how we've resolved the case. This is why. This is what the plea bargain is. This is why. This is what we're going to ask the judge to do. This is why. So we give them the information. But if at the end of the day, the resolution is not something that they're happy with, unfortunately, there's no way for them to contest. They can't appeal the judge's ruling. They can't appeal what the prosecutors have done.
What if a prosecutor says, I'm going to submit a motion to dismiss on this case, and the judge says, I'm not going to grant it?
Then I think the theoretical thing that would happen is you would call us for trial. We would maybe waive a jury, and then you would ask us to put on evidence, and we wouldn't put on any evidence. And then you would say, okay, directed verdict.
You would say there is no evidence. Very good. That's an appellate mind. That's an appellate mind that would respond that way. So in trying to evaluate the strength of a case, you're looking at, can I prove as a prosecutor the who, what, when, how of the elements of a case beyond a reasonable doubt? So when you take a case in as an intake prosecutor and you say, we're going to accept this case, we're going to file it, the grand jury looked at it, they indicted it, what are some of the things that you have to consider when thinking about the difference of beyond a reasonable doubt versus filing a case and having a grand jury look at it?
Well, having the grand jury look at it is simply probable cause, but beyond a reasonable doubt is the highest standard. And juries hold us to that standard. You know that, Judge. I mean, they really do hold us to that standard, and especially at a felony level, take it very seriously. So oftentimes jurors want what we call the CSI or the Hollywood effect. They want the DNA. They want the crime scene photos. You know, they want the expert testimony. And when we're talking about, you know, intimate partner violence or even a sex crime against a child, if there's a delayed outcry, we're not going to have DNA. You know, we're often relying on simply the testimony of the complainants, you know, and hopefully we have some corroborating evidence from police officers, be some medical professionals. But I think jurors are often disappointed that we don't have DNA in our cases. They're like, where's the DNA? Where's the CSI officer?
Sometimes it's word against word.
Correct. It is. And that's for beyond a reasonable doubt. That's tough.
And it's hard to define it, right? We can't tell people exactly what that means. What kind of pressure do you feel? Let's say there's a very high profile case. The media has been following it. You deal with a lot of those kind of cases. And in your mind, you're having a difficult time believing that you could prove that case in front of a jury. What does that look like for you?
We are tasked to do justice. And at the end of the day, if I can't prove my case beyond a reasonable doubt fairly and honestly, then I will probably have to dismiss the case. Maybe it's for further investigation, right? In the hopes that maybe we can develop some more evidence depending on this, if the statute of limitations is still available to us, or maybe there's a different offense, you know, that the evidence meets better. that we can pursue. But, it doesn't mean that we don't just try hard cases.
Right.
We also tried hard cases where there isn't DNA, but we have to still try it, because if I do believe my complainant, and if I believe that the jury will believe them beyond a reasonable doubt, then that could be our case, and maybe that's what justice is. Maybe justice is pursuing a hard case. Maybe justice is dismissing a case that's hard.
What does a normal day in the life of Lauren Scott look like?
Well, the first thing that usually happens is I have a cat that wakes me up by sitting on my chest and either pawing at my face, or this morning licking my face. So that's generally my alarm. And then the day is fairly typical, getting ready for work and coming downtown, parking in our great garage that the commissioners got for us, like that. And, if it's a day where we have docket, usually we're in your court by 9:00 with our files, and we confer with defense attorneys, make offers, we take pleas, we kind of confer and see what's going to come up for trial.
So when my students come in, they talk about this frenzied pace.
Yes.
What is that like? You got a lot of attorneys coming at you at once.
Yeah, I mean, like for today, I think we had a 10-page docket or something. I don't even know how many cases. Sometimes we have a lot of cases set, and if all of the defense attorneys come in at once, there's only one or two prosecutors, and you've got a line of defense attorneys waiting to kind of bend our ear, see if we can resolve the case, give us information, exchange information, and see if we can resolve the case.
How do you manage that kind of caseload?
It's tough.
Yeah.
I mean, in all honesty, it is.
Yeah.
It's tough.
I mean, you're looking at a lot of different cases, a lot of different fact patterns, tons of attorneys. You have the judge calling you up to do pleas and deal with other matters in front of the bench.
Yeah. I mean, we have to try to be as organized as possible. Definitely keeping notes is the only way that we can do it. Luckily, we have a system where we have the ability to sort of keep notes that are attached to a case in a digital form. So I'm always going back to my notes, because I might have a defense attorney come up and be like, hey, remember we talked about this case and I said this and this and this. That's probably true. We probably did have that conversation, but I have no memory of it. So let me check my notes, and then I'll go in and kind of look at, a synopsis of what I kind of think about the case, pros and cons, and what the previous conversations with the complainants have been, the previous conversations with the defense attorneys have been. So notes are essential in order to do this job.
And then you have a team, right? You have a team that's helping you in the court.
Yes. There's actually, right now, we've got 3 family violence prosecutors in your court, which is great.
And then you have an investigator, and you have the victim.
We have the victim's advocate. We have an investigator. We also have a paralegal who helps us comply with that Michael Martin Act that we talked about before, helps us get all of the evidence uploaded into a database that the defense attorneys have access to. We have a CVL. So she's called a crime victim liaison. So she's somebody who actually reaches out to our complainants before the cases even get indicted. So we have contact as early on as we possibly can. So yeah, it's a whole team just assigned to your court, Judge, and then all of the judges have a similar team assigned to them. So it's a pretty big, complex process.
So then you have a frenzied docket until about 12:30 or 1, and then?
Yep. And then it's probably usually eating at my desk, sometime walking to HEB, and then eating at my desk, making phone calls, pre-trialing witnesses. We try to sneak witnesses in every free moment that we have, talking to officers, talking to lay witnesses, calling attorneys, and then just sifting through the evidence. I think this afternoon before I came down here, just watching body worn camera, just watching forensic interviews and witness statements and processing our cases.
Taking a lot of notes.
Yeah.
And then?
And then I go home. So like yourself, Judge, I like to do a little bit of physical activity after work. So I might go do yoga, or I might go for a walk, or go for a run. So do something like that. I try to do a little bit of something every day, and then go home and hang out with my husband and the cats.
Well,
I sound like a cat lady, Judge. Thanks.
Well, it depends how many cats you have. How many cats do you have?
Oh, I've got 3, Judge. I think that officially makes me a cat lady.
Yeah. I agree. So you mentioned yoga. You're a yoga instructor, is that right?
I am. In addition to being a lawyer, back in 2018, I got my 200-hour yoga teacher certificate. So I am Yoga Alliance certified to teach yoga.
What kind of yoga do you teach?
I teach what I call a powerful vinyasa class. So it's a heated yoga. It's it's not for the faint of heart. So it's challenging yoga, but it's really great for your mind and your body.
On occasion, I've gone so far as to consider taking a class with you.
I think I've been encouraging you and asking you to do yoga for longer than you've been asking me to do this podcast.
I think I'm overdue. I think now it's my turn, right? Now, here's an interesting thing that I've learned from you as well. When I was in law school, I was a bartender and a waiter, but you did the same things.
I did.
Where did you work?
I worked at several restaurants. So back when I was still in Louisiana, I worked at Ruth's Chris Steakhouse. I'm sure most people are familiar with that one. That was a great experience. I worked there back when even Ruth was still alive. So I even got to talk to her a few occasions. So that was a steakhouse that I worked at. When I moved to Texas, I first lived in Marble Falls, Texas, if you're familiar with Marble Falls.
I've driven through it.
And there's a couple of restaurants I worked at. I worked at a Jamaican food place called Jammin' House. I worked at a little bistro called Cafe 909, which was very nice. Very small, intimate, open air kitchen. And then I worked at this bar called the Wild Horse Grill, which was super fun. So yeah, I probably in total waited tables and bartended for 10 plus years throughout my life to support myself and college and my kiddo at the time. So
what's your best drink to make? What's your best cocktail?
Love to make a gin and tonic.
Yeah?
Yes, I love a gin and tonic.
What is it about the gin and tonic? You got the little mint and you got the little...
I prefer berries, so strawberries or blackberries with some lime or other citrus, so you can really kind of make it fancy. I like to do that.
I was really good at pouring a draft beer. I had special talent in doing that.
You know what? There actually is a talent to that. I guess people don't know it. If you don't have the keg properly prepped, then you're going to get a bunch of head on your beer, and nobody wants a bunch of foam on their beer.
You know it. It's all about the air, right? It's all about the oxygen. Well, my dad used to really love Elvis, and I grew up listening to a lot of Elvis Presley music. So what significance does Elvis have in your life?
Well, Judge, you probably don't know this about me, but my husband and I eloped to Vegas, and we actually got married by an Elvis impersonator who sang to us. That was great. And I was wearing blue suede shoes because it felt appropriate. So it was super fun. I would do it again and highly recommend it to everybody out there.
Ain't no reason to make a big deal about it. Huh?
Just elope. It's great.
All right, Lauren, any last words that you would have for anybody out there listening?
Well, I think specifically what I would like, if you're a complainant or if you're a victim of a crime, know that there are services out there. I think that maybe in the show notes, we'll put some links to the Texas Department Crime Victim Services, and it's located in Austin, Texas. And they have valuable resources. They've got phone numbers, email addresses, and a whole web page with tons of documents if crime victims are interested in finding out more about what their rights are under the criminal justice system. Yeah, so I would want, if there are victims of crime out there that want more information, I would point them to the Texas Department of Criminal Services, specifically the Crime Victim Services Division. They have a phone number, 1-800-848-4284. They also have an email, victim, victim.svc at tdcj.texas.gov. And they also have a website at tdcj.texas.gov. Or you can just use your friendly Google browser. Google search Texas Crime Victim Services. Their website will come up. They've got PowerPoints. They've got video presentations. They have brochures that can kind of help a person who might have been a victim of a crime understand what their rights are under the laws of Texas.
That's great. And we're going to include those exact links on the website at beyondthegavelpodcast.com for anybody that wants to go on there and have those resources available to them.
Thank you, Judge.
Absolutely. Well, Lauren, thank you for coming in and speaking to me.
I really had a good time, Judge. Thanks for trusting me to be on your podcast.
Thank you so much for making it that way. Well, you've reached the end of this episode. Thank you so much for listening. We'll be back in 2 weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.